Warner. I lead product marketing at Privado.ai. And yeah, we're very excited today to have Matthew Pearson here. He's a leading expert in CIPA litigation, and he's got a lot to discuss today. I know this is a big topic for a lot of people in privacy. And yeah, so before we get started, though, I want to let everyone know that today's webinar will be recorded, and the recording and the slides will be sent out to everyone after today's session over email. Also, please do submit your questions throughout to the Q&A. We will monitor those and answer those as they come in, and then answer any remaining ones at the end of the session. And so, yeah, I'll pass it off to Matthew Pearson. Thank you so much for joining us.
Thanks, Ben, and thanks for everybody for joining. I know this is a well-discussed topic, maybe not a topic everybody wants to delve into, because when I talk to people in privacy, generally litigation is not their friend and they don't want to deal with it. But I promise not to scare you too bad. And like Ben said, if you have any questions or anything like that, I want this to be interactive. I don't want to just be talking at everybody the whole time. So if you have any questions, throw them in there. I'll do my best to answer them. I will say when I do this, sometimes I get questions like, hey, I'm running this on my website and this happened and I got this demand letter with these allegations. I can't get that specific, but happy to answer any questions anybody may have. All right, so that's me. I want to start by kind of talking about how we got here. Probably within the last 2 years, maybe 18 months to 24 months ago, I saw just a ridiculous amount of lawsuits being filed because I read each lawsuit, a summary of each lawsuit filed every day in California. And I started seeing CIPA. And, you know, when it first started, it was generally the same individuals. I'm sure we're all aware of the individuals about whom I'm speaking, who were filing these. And it was two plaintiffs' firms, and they were aggressively filing these lawsuits. The problem is that for every lawsuit filed, and I don't have the exact numbers, but for every lawsuit filed, I would say there's probably 10 to 100 demand letters that I don't know about. And at least initially, most courts, in California were pretty skeptical of these claims. But as the litigation kept going, as these cases got into federal court, we being defendants, got some pretty bad rulings for us, which only fueled the fire. And plaintiffs knew that. So what we were dealing with in the beginning was demand letters, and I'm sure we're still dealing with it. I'm sure many of you on this call are dealing with it, but you feel like you're between a rock and a hard place because you get a demand letter, and just like plaintiff knows, that the case is going to be expensive to litigate. Litigation is expensive, and this is I wouldn't say particularly expensive area of litigation, but it's not rote or cut and dry. And so you're put in between a rock and a hard place between paying what felt like an extortion payment versus paying someone like me to litigate this with no guarantee of a win. And unfortunately, when you get in that situation, you're almost feeding the beast. And that is, you settle a case for, let's say, hypothetically, $15,000 or $20,000. That $15,000 or $20,000 then just funds the additional 6,000, 10,000 demand letters or complaints that get filed after that. So it really was like a snake eating its tail here. But while I'm not extremely optimistic of where things are going, I do think we are going to see some changes. We are going to see some certainty, and we can kind of talk about that as we move forward. So let's start very, very basic. What is CIPA? CIPA is a law that was enacted in 1967 that I think most people would agree had no intention of applying to internet, to cookies, to web traffic, or anything like that. The problem is that it comes with a $5,000 statutory penalty per violation. And you can imagine how enticing that is to a plaintiff's counsel when you don't have to prove damages. All you have to do is say you violated the law, therefore you owe me $5,000. And just so we're kind of all on the same page, CIPA is the same statute. The one we're talking about now is the same statute that resulted in everybody hearing, hey, this call may be monitored or recorded for quality assurance purposes. It applies to telephones, just as the courts have interpreted it. It applies to the internet. And I want you to keep in mind that that disclosure largely got rid of these claims as it related to telephone calls. So something to keep in mind as we move forward. So what does CIPA actually regulate? There are three provisions in CIPA that drive the litigation. 631, which is wiretapping. Basically, what the statute was I guess not intended, but what it does regulate is the learning or reading of communications while they're in transit from the person sending it to the recipient. So a third party is basically looking into these communications and reading them while they're in transit. The problem is, because I'm sure all of you on this call, or most of you, would say, well, we're not the one intercepting. If you're a website operator, you say, this communication was intended for us. Why the heck are we being sued? The fourth clause of CIPA 631 makes it so that you are derivatively, if you're a website operator, if you installed the technology that's at issue, you are derivatively liable for that interception. So if you aid or assist in that interception, you are liable just as the quote unquote interceptor would be. That's how all of these lawsuits have been brought against website operators and not the quote unquote or alleged interceptors, because there is some derivative liability there. 632, I think you may not know CIPA 632, but you know the statute because that's the one that resulted in this call may be monitored or recorded for quality assurance purposes. It is an unlawful recording statute. And everybody's favorite 638.51, which is the pen register trap and trace side of CIPA. Pen register trap and trace was like probably the last evolution of these claims. Effectively, what a pen register or trap and trace device is if you've ever watched kind of an old cop show where there are cops sitting in a dark room watching numbers go in and numbers go out, monitoring a telephone call. That's a pen register trap and trace device. Now it's been applied to the internet, and now we're talking IP addresses and whether IP addresses are comparable to telephone numbers, all quite frankly up for debate, or in my mind up for debate. But that's the general layout of CIPA. And then there's 637.2, which is the private right of action, which says anybody injured by a violation of CIPA can bring a claim for $5,000 in statutory damages. So why CIPA? Why now? The why CIPA is pretty easy. $5,000 in statutory damages. People always ask me, okay, CIPA is the hot thing right now. What's next? And quite frankly, I can't always predict what the next thing is going to be. I'm reluctant to give plaintiffs' counsel any credit, but man, are they creative and clever when it comes to finding statutes that no one expected to apply to conduct that they sue under. CIPA was one of them. Michigan had a statute, was one of them. The VPPA that we've probably all heard of was barely ever litigated. Now it's very hotly litigated. So I can't necessarily tell you what statute it's going to be, but what I can tell you is it's going to be a statute with statutory damages. Um, these claims need to be lucrative enough for plaintiffs' counsel to file them repeatedly and litigate them. And quite frankly, if what they're trying to prove is that each individual was damaged by whatever it is that happened, that's very difficult and quite frankly doesn't add up to very much in the end. But with CIPA or with the VPPA or BIPA or basically anything that's an acronym, if there's statutory damages, it adds up incredibly quickly. And it's scary because the exposure gets massive. So why now? Two things. The courts have generally expanded the reach of CIPA over the last probably 5-10 years, but really the last 2 years, both to whom the law applies and where you can be sued based on the law. And this one generally throws people for a loop. I think that the CCPA gave rise to a lot of these claims. I'll explain why later. So the technological evolution of CIPA, and you don't need to know these cases or read through them, but what I hear often from plaintiffs or from, I see somebody wrote in there, The Wire. Yes, that's exactly what I was talking about. I hear often from clients that, this is new. This is a new thing. Honestly, it's not that new. If you look there, 2009, in this Valentine case, it reads almost exactly like the claims that are being asserted here. The only difference is in those claims, it was not easy to do what plaintiffs claim is companies are doing, right? So in 2009, it was like an actual physical device that was attached to a modem that was tracking things. Now, because it is so, I don't want to say easy, but much easier to install and use this technology, it's far more prevalent. In the past, it may have been companies focused on this exact thing, this type of tracking. It may have been companies who are, for the time, very technologically advanced. Now, I mean, you are hard pressed to go to a website. I am hard pressed to go to a website where I don't take a look at what's running and see something that could arguably qualify as something that would trigger an alleged CIPA violation. It's just everywhere. And you can move through these and kind of see as things evolve. Session replay was a big thing. The chat bot started this whole 631 revolution. The end result. This is something that I put together. I wouldn't use it as like the end all be all or the Bible, but the way that I've seen these things kind of play out is with CIPA's expansion, you have the telephone side of things, and then you have the internet side of things. Right now, we're seeing far more on the internet side of things. 10 years ago, it was almost exclusively on the telephone side of things. I do think the telephone side of things is going to come back a little bit. And the reason I say that is if you look at the bottom left there, artificial intelligence, we are seeing a good amount of claims based on the use of artificial intelligence as it relates to telephone calls made to a company. I think we've all probably heard about or seen companies offering, hey, we can provide artificial intelligence for your customer service calls. What that can do is make recommendations for your customer service agents, how to respond, provide information, the like. I've seen maybe 10 class actions in the last 3 months saying that artificial intelligence is actually a third-party eavesdropper on the phone call, triggering 632 protections. I don't know where those claims are going to go. They're very early on. It's ultimately going to turn on whether artificial intelligence is considered a third party or just an extension of the company. But I do think we're going to see some litigation there. On the right-hand side is the internet side of things, chatbot, right? That started it. Session replay. And the reason session replay was so prevalent early on is because if you think about wiretapping or if you think about recording, it seems like a closer analog to session replay, almost like, hey, we can recreate a session on the internet. It looks like someone's looking over your shoulder. So it looked closer to what historically a CIPA violation would look like. And then we've moved into the event tracking, the pixel, the SDKs, real-time bidding, which is a big issue right now. And I think as, you know, generally my practice goes, my practice evolves as the technology evolves. And I think we're going to see claims evolve as the technology evolves. On the flip side of that is the extraterritorial expansion of CIPA. Basically, the courts have interpreted CIPA to apply to people who are in California. So if you're a company in California, CIPA definitely applies. Or people who are interacting with people in California. And it's that second one that's tough, especially from internet-based traffic where your website is either nationally available or globally available, and you don't really know where traffic is coming from. It's tough because, you know, one person or 10 people from California visit your website, CIPA applies to you, and you're like, well, I'm a Florida company doing business in Florida. Why am I being dragged in on this one? Courts have said, hey, you know, CIPA is intended to protect the privacy of California residents, and this is a California resident. On the personal jurisdiction front, so separate and apart from whether the law applies to you, whether or not your company, if you are a non-California entity, can you be sued in California? I was really looking forward to the Briskin opinion that came out of the Ninth Circuit. I thought it was going to kind of rein in all of these claims brought in California against companies who have no physical presence and really no connection to California other than California residents go to their website. Unfortunately, Briskin didn't come out the way that I had hoped, or quite frankly, the way that I think it should have come out. And basically what the Ninth Circuit said is, if you know that a person's in California or that people in California are visiting your website, you may be subject to personal jurisdiction in California. Now, granted, Briskin was against Shopify, and Shopify, right, is a little bit differently situated than normal website operators. I still think there's grounds. I, in fact, have a couple motions right now pending to dismiss for lack of personal jurisdiction because the website operator doesn't really know where these people are or how they're getting to the website or anything like that. But it wasn't the win that we had hoped, and it really has opened the door to drag in foreign companies, and by foreign I mean non-California, into California court. So the CCPA, this is the one that kind of throws people for a loop. CCPA was intended to regulate this conduct. CCPA implemented an opt-out regime, and that was by choice, right? Because the GDPR was already around by the time California enacted the CCPA. So they ostensibly, the legislature knew that an opt-in regime was possible, yet they made the choice for an opt-out regime. And the problem here, and I hear this all the time, is CIPA, the way it's been interpreted, and the CCPA require two different things. So the CCPA says you need to give people the opportunity to opt out of sales and shares. So that means, it generally means that you can do what you're doing until someone tells you not to, for the most part. CIPA, the way it's been interpreted, says you don't get to do what you're doing until you get affirmative prior consent. So the two standards kind of butt heads. And I'll tell you, I've tried to argue and have argued that the CCPA should preempt CIPA, that the CCPA was intended to regulate this conduct, CIPA was not. And now we're just doing square peg round hole. And quite frankly, we're allowing plaintiffs' counsel to rewrite the law in California as it relates to this conduct. The unfortunate part is there is one line in an otherwise very lengthy CCPA statute that says, to the extent any other statute provides greater protection, privacy protection than the CCPA, that statute governs. And I think we'd all say that requiring prior affirmative consent is more protective than opt-out consent. And courts have said that. And basically, our argument that the CCPA should preempt CIPA has been thrown out the door. And quite frankly, I think it's done just because of that one line, which probably when the legislature wrote it, they had no intention of, CIPA, the consent standard under CIPA overriding this opt-out regime, but it has. So the one thing to take away here, and I hear this. So the one thing to take away here is, and I hear it all the time, is how could I possibly be sued for doing this if I'm CCPA compliant? The answer is CCPA compliance does not equal CIPA compliance. It just doesn't. In fact, I kind of divide them into two buckets. So you have the CCPA side of things, which is more regulatory, right? Although plaintiffs have tried to sue under the CCPA for this type of conduct, there's really no private right of action, or in my opinion, no private right of action that should allow it. So to the extent you are not compliant with the CCPA, you may have some regulatory issues, but I don't see it as so much of a litigation risk. So that's the regulatory compliance side of things. On the other side is the CCPA litigation risk, right? I haven't seen any regulatory action under CIPA as it relates to the collection of information from a website or anything like that. So the regulatory side is not there, but the litigation side is huge. So if you draw the two, if you separate the two, you can say, okay, we are CCPA compliant. And oh, by the way, we are taking all of these steps in order to be, I don't want to say CIPA compliant, because what would comply with CIPA given this nature of the law right now is difficult to ascertain. But what I would say is there are steps you can take to protect yourself from a litigation side of things that are separate and apart from the CCPA side of things. And we'll talk a little bit about that. So what are the plaintiffs even alleging in these cases? Because when I talk to clients generally, and it's better now, but in the beginning, everybody said, okay, we don't do this. Say, well, take a look at your website. You are running some stuff. And they said, well, we certainly aren't collecting PII. And I think in the ordinary sense of what PII is, I agree with you. But you got to remember that what plaintiffs are alleging is that you are collecting data that allow a third party to effectively identify the user of a website. And so, now companies are a little more aware of things running on the website, third-party transmissions, what's being sent to third parties, and quite frankly, what's the content? What does that look like? Because I think we have to dispel the notion or shed ourselves of the notion that because we're not sharing name, address, telephone number, the like, we're not running any risk of a CIPA claim. In fact, it's kind of, I wouldn't say the opposite, but 99% of my cases are not based on the sharing of name, address, telephone number, or anything like that. They are based on the sharing of IP address, device metadata, and unique cookie values. And then the argument that information, when provided to a specific third party, can identify individuals. It all comes down to GET requests, POST requests, transmissions on your website. I'm sure everybody on here, or most people, have received a demand letter, either from a firm that loves to go to arbitration, or two other firms, one of which located in Newport Beach, that send out these demand letters, and they have this grainy screenshot. And you're like, what the heck is this? and it's dev tools looking at your website saying, look at all these third-party transmissions. Here's what you're sending. That's what plaintiff is alleging, that those transmissions to third parties from your website are violating CIPA. And we'll talk a little bit about this, but just so you know, all of those transmissions are completely visible to anybody on the internet, right? I can go on your website, right click, inspect, and see what's going on. So can plaintiff's counsel. In fact, that's how plaintiff's counsel is drumming up all of these claims. I don't know if they have like a bunch of minions sitting in the basement going from website to website looking for specific technology or how they're doing it, but that's kind of how it works. They're going from site to site, right click, inspect what's being run. All right, I see a couple red flags here. I send it up the flagpole to the plaintiff's counsel. They drum up some generic demand letter, send it off, and then you're in between a rock and a hard place because you can either settle this for more than you want to pay, you don't think you did anything wrong, or you can litigate it for probably more money just to have the opportunity to win. This is what the transmissions look like, just so everybody knows. You won't see name, you won't see address, you won't see anything like that in there. But the argument is that the more data points that are collected, so let's say screen resolution, browser type, browser version, IP address, operating system, operating version, height, width of my screen, device used, all of that information is ultimately aggregated to differentiate one user from another on the internet. There is some merit to that argument. In fact, I mean, these third parties are largely in the business of being able to identify or at least zone in on certain groups of individuals. That said, the claim that because Matt Pearson went on a website and you got my IP address and my screen height and screen width, that you know exactly who I am is bogus. On the one hand, you don't know who's using the device, right? My wife could be using it. My kid could be using it. And also, like, IP addresses change depending on where you are, even depending on the lease of your IP address. And a lot of people use the same devices, right? So it's not a slam dunk that there's actual identification going on, but plaintiffs really have done a good job of drumming up enough information to let courts believe that that's what's happening. So here's the one everybody wants to hear. What are my options? So it's a sliding scale, right? I can tell you what the silver bullets are, the things that will make it so I won't say you won't get sued, but the likelihood of you getting sued is pretty slim. And even if you do get sued, you have a great defense. So the first one is remove the tracking technologies from your website. No one is going to do that. I mean, it is a very rare situation in which I can tell a client that, hey, if you want to not do this, you want to not be involved, just take all this stuff off the website, and they do it, right? You need to be pretty uniquely positioned to do that. Most companies have a reason for putting this stuff on the website. And if they don't, it shouldn't be on there. But if they do, there's probably a reason to keep it, right? It's a balancing act. You can always implement an affirmative opt-in approach, like a GDPR approach. Again, that's a pretty tough sell on my end, especially to my clients, because yes, most people ignore those cookie banners, but if you give somebody the option to affirmatively opt in, so that isn't the option to say, please don't track me. It is the option to do nothing and not be tracked. Most people are going to do nothing. They're not going to say, yeah, hey, I'm here, please track me. So you're going to go from collecting, let's say, 95% of the data you're collecting right now from your users to something significantly less, maybe 20%, 15%. And that's a big hit, right? So the data being collected here is generally leveraged for marketing, and good luck telling your marketing team, hey, you're just not going to have this data anymore. Now, that said, what I see quite frequently is legacy technology. And what I mean by that is you were running a TikTok campaign 6 months ago. It ended 6 months ago, but the technology, the tracking, the TikTok JavaScript is still on your website, even though you're not using it. It's so easy to add this technology that it often remains on the site long after its usefulness has run its course. So, you know, if you are going to reach a point where you accept some amount of litigation exposure because from a business point of view, it makes sense to continue to use it, you definitely need to take a look and say, all right, if we're going to accept this exposure, we're going to limit it as much as possible by only having on the website things that actually have a business need and purpose and justification. The third one, and this is the one that most of my clients take, is I basically call it the don't be the slowest gazelle in the pack approach. Make yourself harder to sue. This isn't a silver bullet. You likely will still get demand letters and you may get lawsuits. But what you are doing is better positioning yourself in the litigation when it does occur. The internal tug of war, the thing that I always deal with is every client is like, don't put anything on my website that drives away traffic. Don't make it more difficult. Don't make it slower. We're fine with whatever you want to do consent wise, as long as it doesn't create friction. So my goal here is to come up with options that provide protection for a company without increasing or significantly increasing friction to a user. We want a user to come to the website. We want a user to engage. But we also want to make sure is that we are not effectively leaving ourselves open for these continuous lawsuits, demand letters, and death by 1,000 cuts. Revise your disclosures. Step one, revise your disclosures and be painfully transparent. I see all these cookie banners that say things like, we use cookies to enhance your experience. Like, that doesn't really say much. And this is not a situation, I kind of explained it before, this is not a situation in which you want to hide the ball or you need to hide the ball. It's all publicly available. I can see it. Plaintiff's counsel can see it. So you're not shielding yourself from making your disclosures vague or trying to make them sound pretty or the like. Remember, disclosures on the website are my version of this call may be monitored or recorded for quality assurance purposes, right? I need to go to the court and say, plaintiff consented to what we were doing because we told them what we were doing early on and they continued to use the website, right? If I go to the court and say, Your Honor, plaintiff consented to what we were doing because we told them that we were using cookies to enhance their experience, there's no world in which the court's going to say that's consent to do what we did, because the judge is not going to understand what that means. I barely understand what that means. Be painfully transparent and focus less on the technology being used and more on what's happening, right? We throw around these terms like cookies, beacons, pixels. Think about this from the layperson's perspective. Does the layperson care if you're using a cookie or a pixel or a beacon, or does the layperson care that you're collecting information and sharing it with these third parties for this specific reason? And if they don't want you to do that, then they should go away, right? Make it easy to understand. Think about it as if I'm explaining this to the judge of saying, we told the plaintiff exactly what we were doing, and the plaintiff made the decision to continue. So the plaintiff impliedly consented to what we were doing. In that vein, you got to link to your privacy policy in a cookie banner or a disclosure. I think you should, but do not think that because you explain this in detail in your privacy policy, and because you link to it either on your site or your cookie banner, that's going to be sufficient consent. It's not. All of this technology, for the most part, is firing almost immediately. And if you are banking on an individual clicking on your privacy policy, scrolling through, reading it all, understanding it, and then thinking, well, I consented to do this. No, I mean, all of the claims that I'm seeing are, even on the cookie banner front, all of this stuff is firing before plaintiff even has a chance to understand what's going on. So don't rely on some prolix privacy policy that takes 3 links to get there. Be upfront, be early, be transparent. These are just some examples that I pulled. You know, I like the use of tracking technologies, right? That actually resonates with someone, whereas we use cookies. I think a lot of people throw around that term cookies. I think people not even in this area throw around the term cookies. The understanding of what a cookie is or how it operates is lacking. So avoid it. Tell people what you're doing, not necessarily how you're doing it, unless you're using session replay, which we will talk about. Update your site architecture. So this one often strikes people as odd, but my issue is generally not that the company didn't explain somewhere what it was doing. It was that it didn't explain what it was doing early enough, right? If this really does come down to a timing issue, we want to be able to say either that the notification, the disclosure was given to the user before anything happened or pretty dang closely after it happened. And that all comes down to site architecture. So, for example, a cookie banner, I think we've generally viewed those as this is how we comply with the CCPA, or this is some type of thing we can do to help with regulatory. I like to think of it as a way to better protect myself from litigation, right? If we think about it as we're trying to provide notice as early as possible without increasing friction. If you already have a cookie banner, that friction's there, right? Use the cookie banner to your advantage. Be transparent, make disclosures. That cookie banner should pop up immediately. Quite frankly, I think it should pop up every time. And make the disclosure. That way you have the argument that every time this person came to your website, they knew what was going on. They knew early, they knew often, and it gives me an argument for consent after the fact. There are other options. I've seen companies moving into a setup where I go to the website, there's a pop-up. I don't get to do anything beyond that pop-up until I make a decision of what I want to do. I've seen other companies have that same pop-up and say, basically, if you want us to track you, you click yes. Otherwise, if you X out of here, we're not going to track you. There's so many variations and ways to skin this cat. But ultimately, what you want to focus on is transparent disclosure very, very early. So that includes your disclosures and your site architecture. This is one I was talking about. This was actually tested in the courts. And what this was when you got onto the site, this popped up and you couldn't do anything until you engaged with it. Granted, if we're talking friction, this is like the most friction you could possibly have. It's not going to be for everybody, but I'm just showing you that the sliding scale of you can button up entirely, you can decrease friction, or you can find somewhere in the middle. There's no right answer per se. It's really a business decision of how you want to handle this. We all have terms of use on our website, right? And those terms of use are pretty standard across the board. And they're all buried in the footer of our website. I cannot enforce your terms of use against a website visitor if it's buried in the footer of your website. It's a browser app agreement, and at least in California, it's not going to fly. In order to enforce these terms of use, you need to have notification and a manifestation of assent. And quite frankly, if it's a link at the very bottom of your page that I have to scroll down to and I basically have to look for, I'm not going to be able to show notice, and I'm not going to be able to show a manifestation of assent. So if you're using your terms of use, or I'm sure they were drafted in a way to have litigation control mechanisms, for example, an arbitration agreement, a forum selection clause, a class action waiver, a choice of law provision, a pre-dispute notification provision, it does nothing for you, at least for site visitors, if it's just buried in the footer of your website. So take steps to give me, the litigator, the opportunity to say, this is actually enforceable against these individuals, and here's why. So like we talked about with the cookie banner of include your disclosures in there, make them transparent. You need notice of your terms of use, put it in your cookie banner, right? Have a link to your terms of use in your cookie banner. Immediately, that gives me the opportunity to say, every person that came on the website was notified that their use of the site was governed by the terms of use. In fact, put a link in there so that they can click directly from the cookie banner to your terms of use. And if you want to really belt and suspenders, say, your use of this website is governed by our terms of use, which includes an arbitration provision, a class action waiver, and a forum selection clause or anything. Take steps to put people on notice of the terms you want to enforce. And if you have a cookie banner or any type of pop-up or anything, you're not increasing friction because it's already there. This is just a generic example, but this is a site, and at the very bottom, circled in red, it doesn't even say terms of use. It says legal notices. Like, I can't enforce that, guys. It's just not going to happen. There's no notification. There's no manifestation of assent. So in that vein, your terms of use are not a placeholder. Update them. You should be tailoring them to trends in litigation. We've seen a lot of litigation recently over, arbitrations, right? We've heard about mass arbitrations, the weaponization of arbitration. What you should be doing is taking a look at your terms of use and bumping it up to where you think the exposure is, the litigation exposure in your business as it relates to your website. Pre-dispute notification provisions, right? So we've gotten to the point where we have an argument that the terms of use applies to anybody on the website. Let's build that up. Let's strengthen the provisions in there to protect us. Put a pre-dispute notification provision in there. You can set it up so that it's a condition precedent that everybody has to reach out to you prior to filing suit and give you 30 days to resolve the dispute, right? Pick off the individuals, the squeaky wheels, before it turns into a class action. Choice of law provision. I know we had kind of discussed that this law generally applies to everybody, but take a shot. Say California law doesn't apply. Forum selection clause, same thing. Say, you have to file in this state or this state. Give it a shot. Standalone class action waivers. Everybody is like, California doesn't enforce those. And I would agree with you for the most part. But what the California court is focused on is they don't want companies immunizing themselves from small claims. So for example, you've seen these class actions where everybody gets a buck, right? But there's a gajillion people that get a buck, right? That incentivizes an attorney to file that lawsuit. If everybody just gets a buck and you can't have a class action, no one's ever going to file. So there are creative ways to address that issue while still maintaining a class action waiver and giving yourself the opportunity to make an argument. The only thing I would say is, sometimes we'll put in there, hey, if your claim is worth less than X, the class action waiver doesn't apply. What you're trying to do is address that issue the court has identified, but you're always going to put it under the lowest amount of statutory damages available. So what you're doing is effectively saying, if you have a claim that has statutory damages, this class action waiver applies to you. That deals with CIPA, VPPA, BIPA, CMIA, all of that. So everything I'm saying right now is there's no right answer. There's no perfect way to skin the cat, but be creative. This is one that throws people for a loop. I always say this: differentiate between site visitors and site customers. They are very, very differently situated. Site visitors are people that pop on your website, have no relationship with you, create no relationship with you, and then just pop off. Customers are people with whom you have a relationship. Maybe they signed up for an account, they made a purchase, enrolled in a loyalty program, something, some type of interaction back and forth. And the reason I say that is why it's important to differentiate is because, for the most part, in my world, this online privacy world, customers aren't suing you, visitors are suing you, right? So you've got to differentiate between them because one has far more exposure than the other, and because you have certain options with ones that you don't have with the others. Here's the biggest one: arbitration. Mass arbitration is a real thing. Plaintiffs' counsel know that arbitration is generally more expensive than it is to just pay off the claim. So what I say is, visitors, you should not have an arbitration provision. Those are the ones that are going to sue you. Those are the ones that are very easy for plaintiffs' counsel to drum up, right? It's very easy to get 1,000 people to say, I went to this website and I left. It's very difficult to get 1,000 people to say, I went and bought this product or created this account on this website, right? So it's much easier for plaintiffs' counsel to drum up mass arbitrations when the arbitration provision applies to visitors. I'm not saying that you shouldn't have an arbitration provision. You should, if you want one, but it should apply to customers, and there should be affirmative consent to it when you are interacting with your customers. Where you get in trouble is where you have an arbitration provision and probably an unenforceable terms of use that applies to everybody. And someone with whom you have no relationship and you cannot verify ever went to your website sends you an arbitration demand, and you're like, what the heck am I supposed to do with this? Right? That's the situation you don't want to be in. And you don't need to have an arbitration provision as it relates to visitors. In fact, if I had my druthers in these lawsuits, I wouldn't be in arbitration. I would be in court in a class action, because there are far more defenses to a class action in court than there are to individual arbitrations in arbitration.
Hey, Matthew, we're getting a lot of good questions. I haven't stopped you because you're going through a lot of good, meaty content. There was one about the previous slide. How do you address site visitors who are visually impaired looking for a claim? I suspect by adding the TOU to the cookie banners.
Yeah, I mean, I unfortunately, with the way that I see it is like on the ADA side of things, if they want to find a claim, they can. I mean, it's incredibly frustrating. And recently I've seen a lot of CIPA claims married with ADA website ADA claims, generally bottom feeder quick settlements. But I to be honest, I'm not sure. It's something that I would need to look into. I don't do a ton on the ADA side of things, but I know there are a ton of products out there that say they can make you ADA compliant. I also know that plaintiffs' counsel have identified certain products that they believe are not ADA compliant and are searching the web for anybody running that product. But to the extent whoever asked that question wants to email me, we do have a person here who's addressing ADA stuff, and I'd be happy to put you in touch. But sorry, I wouldn't want to give you any false information there.
Thank you.
Yeah. And sorry, I was trying to look at the questions and talk, but I got distracted with all the talking.
No, it's been good you going through all these different steps for what to do about it.
Yeah. Wait, I'll answer this one. Any expectations for SB 690 to do away with the CIPA nightmare? No. So I worked directly with the lobbyists on SB 690. And we made it through the Senate with not a lot of pushback. And then once we got into the other house, plaintiffs' counsel woke up, and the versions that were going back and forth were so far apart. I would love, love, love to say that SB 690 is going to correct this. The problem is recently these lawsuits are not being filed. I mean, they still are being filed, but not exclusively filed against mom and pop businesses or just website operators or anything like that. They're starting to go after the actual tech providers. And when you go after the tech providers, like, for example, the Facebooks, the Googles, the big guys, big tech, we lose out on the kind of sob story of, hey, we're trying to do everything right, and we're just getting caught up in this, and it's total nonsense. So the minute that started happening, we lost the emotional side of things, and quite frankly, the way the law was drafted in the first place, it arguably created a carve out for big tech, and I think that's what caused some heartburn getting it through. I will tell you that we are working on some creative arguments to try and very much limit the reach of at least 631 and 638.51. So wiretap and pen register trap and trace. Don't have any rulings on that yet, but I'm hopeful, and we'll see what happens. I could be wrong. I hope I'm wrong. It's just plaintiffs' counsel are pretty powerful in California, and when they woke up and realized that this was going to take some money out of their pocket, they threw up some hurdles, and that bill got put on a 2-year plan pretty quick. The other ones, steps that I was talking about is like server-side tracking with no client-side tags. In my opinion, that generally gets rid of any CIPA exposure, but from what I've been told, right, server-side tracking is a pretty heavy lift on the front end, and also may still require client-side tags. And if that's the case, then you might as well just use the client-side tags all the way. But because CIPA focuses more on the manner in which information is collected, as opposed to what information is collected, if you are getting, or if a third party is getting the information directly from the intended recipient and not, quote unquote, grabbing it or intercepting it, CIPA exposure is greatly limited. Asynchronous tracking, at least for 631 claims. Remember, the claim has to be that a person read, attempted to read, or learn the contents of a communication while it was being sent from, received by, or in transit to. So basically, if you say none of the tracking technologies fires until all communications between the website and the user's browsers have been completed, this should be a good defense to 631 claims. Now, it's very difficult to get courts to understand that side of things. I've tried, it hasn't worked, but creative way to think about CIPA exposure. Here's 690. We talked about it. 690 was effectively supposed to say if you comply with the CCPA, you're not going to be liable under CIPA. We'll see. I'm not super optimistic.
So yeah, we're close to the end here. I just wanted to see if we could answer some of these
Sure.
questions, Matthew. There's one here about trying to win and take these to court. Yeah, do you see what is the benefit of winning? We say we currently are before a favorable judge, and we could potentially win this, but there's also things that get dismissed. Can you see any benefit for seeking good law, or is there nothing we can do to disincentivize these firms?
I mean, there's always a benefit to winning. Remember, a lot of this, the way that this law came about was it snowballed. It was a theory that's got scoffed at, and then one court made a decision, C2 Education, Central District of California, and it snowballed, and it continues to snowball, and it will. One bad order begets another, begets another. So, from my perspective, the more good rulings we can get, the better. That said, I would be lying if I said, you get one good ruling on a motion to dismiss, you're never going to be sued in a CIPA class action again. No. I mean, the way motion to dismiss goes, it's based on the allegations in the complaint. The allegations in the next complaint may be different, right? What I do think from a litigation perspective is because the tech providers are being sued now, they are very, very motivated to fight these. They have to fight these. Um, it's not like a website operator who says, we like having this technology, but it's not necessary for our business. Let's yank it and be done with this. This is their business. This is what they do, right? They are 100% motivated to fight it. And on top of that, there's no knowledge gap. Like when a website operator gets sued for technology running on its website and the plaintiff alleges all of these things that the technology is doing, for the most part, the website operator doesn't know, right? It knows that it's running on the website. It knows that it shows them conversions from whatever social media platform it's running an ad on, and maybe generate some traffic aggregated reports. But there's a big knowledge gap. Not so with these technology providers. So whereas we've been living in this motion to dismiss hell and not really getting any substantive rulings on factual issues, I think that's going to change probably within the next 6 to 12 months. And I can't guarantee that all the rulings are going to be favorable, but we're in a situation right now where any type of clarity would be helpful. Because when a client calls me and asks me, is what I'm doing against the law? And I say, I can't really tell you, that's problematic, right? It's hard to value cases, it's hard to settle cases, it's hard to litigate cases. So the more information we get as these cases progress, the better off everybody's going to be.
Thank you. I've got another one here. Have you been able to figure out why plaintiffs' counsel believe they have a right to attorney fees under CIPA?
No.
No.
I mean, if the problem with the attorney's fees provision is the only way you ever get there is if you take this thing all the way through, right? Otherwise, attorney's fees are just baked into the settlement. So, I mean, they may claim that they're entitled to attorney's fees because they did work, quote unquote, and that's what it costs to settle the case. But none of these have, I mean, as far as I know, other than the Facebook trial, none of these have really gone the distance or even close to the distance. So we haven't really gotten to the point where a plaintiff needs to make a motion for attorney's fees.
Mm. Okay. What's the average lifespan of a typical CIPA case from filing to dismissal or settlement? What's the average settlement value of such cases?
That all depends on who you get sued by. If you get sued by one of the two or three smaller players in this world, the lifespan could be as short as 3 days. We all know, everybody in this space, at least on my side of the V, knows what these things go for. I could tell you, based on who sued you, what the settlement value is. I can tell you that pre-filing, it's probably a little less, maybe $1,000 or $2,000 less. Post-filing bumps up by $1,000 or $2,000 for no reason, by the way. But yeah, I mean, it's generally somewhere in the ballpark of 15 to 25,000 bucks to get rid of an individual action. And if you're willing to pay that, you can settle it very, very quickly. If you get sued by an actual plaintiff's firm, I litigate a lot of these against people who are actually litigating these. They're not in it to settle immediately. They are not in it. You won't get a demand letter. They're not in the business of sending you demand letters. They're in the business of filing complaints. So it largely is driven by who is suing you. And unless you are in like a specific industry, you're probably not going to get the real player. If you're a media company, if you're a healthcare company, financial company, you might get one of the real players. But if you're just a website operator, you're probably going to get it from one of the quick settlement ones. And it just depends on whether you want to pay their amount early or not. If you're in state court, it's going to take a lot longer to get to a ruling on a motion to dismiss. Plaintiff's going to get leave to amend. Your hearing's probably going to be set like 5 months out anyway. I mean, it's a 7 to 12 month process, as painful as that is. Federal court's a little bit different. It goes faster. They're still going to get leave to amend probably. So you're looking at maybe 6 months, but not a lot of work is going on in between that time. You are drafting and filing briefs, but that's it. Shouldn't be engaged in any discovery or anything like that.
Yeah, I know we're wrapping up here. This is a pretty, I would say, accurate comment and question from Chris. It's not actually about privacy, sadly. It's about money and litigation. Would you agree, Matthew?
Yeah, my whole job is about money. I mean, I think you could find some plaintiffs and plaintiffs counsel out there who believe that this is really a privacy issue. I do think they're out there. But for the most part, this is a money grab. That's what it is. Um, and I think, bear with me, I think the claims are actually shifting to reflect that because the more they get filed and the more they're litigated, it's becoming less and less about a privacy violation and more about unjust enrichment. And what I mean by that is the plaintiffs are basically saying, clearly my data has monetary value to you. You should be providing compensation to me for that data. And so while it is a privacy statute and being filed as such, I do think there's a shift towards this is less about privacy and more about a transaction and unjust enrichment. And courts have weighed in on the unjust enrichment part of things. Thus far, they haven't really adopted it, but I'm scared that they might because in rationally, these types of claims make more sense if they're focused less on privacy and more on the transfer and benefit and profit from consumer information.
Okay. Uh, I don't know if you still want to try to finish the rest of the presentation. We still have a lot of people here. Otherwise, we can wrap up and send out the rest of the slides.
Honestly, I touched on a lot of it already. The end is where I see things going. AI is going to be a part of it. I haven't yet figured out necessarily how, but it will be. We've seen it in the telephone space. The question is going to come down to, do we think of AI as a quote unquote third party or just as an extension of the company using it? And that's going to boil down to, what is the AI doing with the data? Are they training on it? Are they using it? Do other companies get the benefit of the data if it's trained on? So that'll all be fleshed out. And the unjust enrichment side of things, I do think that we're going to get to a point where, with the exception of some very sensitive information, medical information, financial information, the like, this is going to pivot a little bit away from the privacy side of things and more towards the transaction side of things and the unjust enrichment side of things.
Awesome. Thank you so much. I think yeah, everyone was very engaged, and we had to say today there's a lot of concern around these cases and these threats. So thank you so much, Matthew. This has been awesome. Yeah, we'll try to follow up with any questions we weren't able to answer. Yeah, I'll say, at Privado, what we've been able to really bring to market over the last year is our web auditor solution to help companies get ahead of these privacy risks on their website. So, continual monitoring and identifying, what data is being shared, whether that data is coming, before or after consent and before or after a banner. So, please check us out if you're interested in using our web auditing solution. And then I'll just say, coming up over the next few weeks, we have another webinar in 2 weeks about our new real-time data mapping AI agent solution. So if you want to join us for that, that'd be great. And then in November, we're having uh, a customer, ESRB, is coming to talk about how they use Privado for their privacy certification program they do for mobile, I guess, video games and toys. So thanks again, everyone, for joining. Thanks again to Matthew's great presentation. And yeah, hope this was helpful.